Welcome to Drunk Beaver Production. This is Jonathan, and tonight we're going to the 40th Circuit in Kentucky with Judge David Williams for a bond revocation hearing. Don't forget to like, subscribe, and share this with a friend. Please enjoy.
Powell versus Cody Smith. We sit down. County Corrections had Mr. Smith up here so he can participate. Mr. Smith, earlier, I had people on Zoom. I wasn't sure that they would completely hear and everything, so I want you to be up here. What do we have here today? It's got a motion for bill of particulars, is that correct?
Yeah, motion for this whole long.
Well, let's do the motion for bill of particulars first. What we got?
Well, I just see that this way you keep Mr. Wittenberg.
Well, wait a second. Y'all move over here and let him behind.
It relates to bond revocation, he doesn't relate to criminal.
Okay.
Basically, he was wanting information regarding the stick that was used to test Mr. Smith at the last court meeting.
Okay.
According to Mr. Payne, I could do it in writing or I can have him testify. They don't track those, but what a lot they come out there. So.
Well, what, you have a motion you want to make then about the entire process and stuff here?
Yes, Your Honor. As Mr. Stockton said, this is a motion over a drug test that occurred the last time my client was in court. And what I was wanting to do was ask some questions and verify that this was an accurate and valid test. Because I don't think that stuff was checked. He had, I'm not sure what counsel he had, but the court appointed him some type of counsel because I wasn't able to be here and I didn't properly give the court notice that I wouldn't be here. But
Well, let's start there. You can't just give the court notice that you're not going to be here. For the last 2 or 3 times, you sent a notice over here that you can't make it. That's not good enough. You need to call a Commonwealth Attorney's office and make arrangements for an alternate date if he agrees. If not, we need to get somebody to stand in. If we let people just summarily send a notice over here that they're not going to be here, we'd never conduct any business. So I don't accept that as a premise that we're stating something. But
Your Honor, respectfully, I have done that. And respectfully, Your Honor, back on February 29th, I was in court here on another case. I informed the court on that date that I had a trial scheduled for a Thursday and Friday that would more likely than not go. And you told me on that date, it's on video, that you only have one motion day a month.
And to get somebody
And
to
to go ahead and do that, just have somebody coming down the calendar or something. And I had to do the same thing on that one because I was in trial. The same thing on his, as soon as I found out that I was going to have the trial, I sent notice to the court. I'm not sure if I contacted Mr. Stockton or not, but I sent
The
notice.
office contacted me. I can't remember the lady's name that I dealt with. We had difficulty trying to arrange a date for something Mr. Wittenberg wasn't available.
Okay, you go ahead and proceed.
Well, I've done my due diligence in trying to make sure and have everyone informed, Your Honor. I've informed the court, I've informed Mr. Stockton. The last time he was here, he was appointed counsel. I'm not sure what counsel he was appointed and stuff. But it's my feelings that that counsel, to the best of my knowledge, he didn't have the case file or anything. And he was given a very little time to prepare for whatever.
Wasn't
hearing.
anything done on the case. He came in here under the influence is what happened.
He was late.
He was late, he wasn't here on time, and then he came in under the influence. So it was direct contempt.
That would probably be on me, Your Honor. because-
And then I called the public advocate up and asked him to stand in to see if he wanted to talk to him. I believe it was Mr. Penny.
Yeah.
Is that correct? That's correct. Would you go ahead?
Your Honor, that would be my fault. I'll accept responsibility for that. I had contacted my client. I told him, I said, I'm in a trial that starts Tuesday. I said, more likely than not, it goes
He
Friday.
did all right with the late. He
Well-
came, they got in contact. I was okay with the late because it could have been a miscommunication. But it's not your responsibility that he came up here under the influence. He was obviously under the influence, so I had to test him.
Well,
And what did, I want you to raise your right.
if I can finish, Your Honor, before
Go
we do
ahead,
that.
sir, absolutely.
I told him not to be here because I told him I would not be here as his counsel, his privately trained counsel to represent him. And, I told him not to come, is why he didn't come that morning.
Well, was he told previous that at 8 a.m. that day he was told did he call in? What happened? called in to ask if he had to be here to that day, and he was told to be here. Were you aware of that?
No, I was not, Your
Well,
Honor.
no, you weren't, because you would have told me if you'd been aware of it, so I'm not saying you were, but he called in here, asked if he had to be here today. Was told he had to be here that day. Then he didn't show up, came in late. When he came in, he was under the influence. Now, I can't let people come in here under the influence and not test them for their own safety. If people come into this court and they've got all kinds of drug cocktail in them or something like that, and I let them go out the door and they get in a car and run over somebody, or they die themselves, and we have responsibility. Now, I don't know this gentleman, and I don't have anything against him, but he was under a bond not to be taking any of these illegal substances, anything. So not only was he in violation of his bond in situation, but he was under the influence. That's what got him put in jail. Okay, now if you won't take testimony from this
I do, Your
officer,
Honor.
very good. Raise your right hand. I swear the testimony about you gives the truth, the whole truth, and nothing but the truth.
Yes, sir.
You may inquire.
Can you state your full name for the record?
Carson Payne, probation and parole officer for District 20 Monticello office, supervise Clinton County probation and parolees.
Okay, how long have you held that position?
I have been with the Department of Corrections right at 11 years. However, I've done different positions. I've been back since December of this year as an officer.
Now, I think the date is February 11th. I may be mistaken, but February 11th, I think is the date that you were here and you drug tested Mr. Schmidt. Do you know if that's,
I think it was the last court day. It was April 11th.
uh,
April 11th.
I may be, yeah, it may be April. I may be mistaken on the date.
Yes, April 11th.
But you tested him from the
Yes, sir.
court orders and stuff like that. The court requested you test him.
Yes, sir.
What type of training do you do when you do your testing, like to do your job? Do you go through certain training, annual or what?
We have yearly in-service. When I was hired 11 years ago, I was trained on drug test. They basically took me in the room when they drug tested somebody and I watched them and they told me how to do it, and that's how we've done it.
Do you get recertified every year or do you take?
We do
updated
not
classes?
have drug test certification.
Okay. On the date that you gave Mr. Smith the test, can you go through exactly what you did, what the procedure is when you give a test like that, step by
Well,
step?
I was sitting there and judge asked me, told me to get a test ready. And I said, I've got one right here in my bag. When he come back in, he said, test him. And I walked over here and I reached down in my bag and drawed a random cup out. I got 3 or 4 left in there. Drawed one out, walked back there, tore the lid off, handed it to him. First, I asked him if he was gonna be dirty. He said he was gonna be clean. I handed it to him. It took him a few minutes. He provided a sample. I put the lid back on it. I'm just gonna waste this test to show you. After pull it out of this bag.
You're blocking the camera off, and if
Yeah.
you're on camera there, go.
Oh, thank you.
After he, yeah, right there.
My bad.
After he filled it up. I'm thinking, which I do 100 drug tests a month. He had a pretty good amount in it. I reached over here. Actually, I probably pulled my pocket knife out and peeled this back. Peeled it back. I read it. I told him to come with me. I walked straight up to the bench and I told Judge that he was positive for oxy, meth, and Suboxone. Held it like this, and the judge said, thank you. And I walked back in there and poured it out, and that was it.
When you give a test like that, is there any paperwork associated with that, any forms you fill out or anything?
If you're on probation, if you're on my caseload and you come into my office, I'm gonna come in, I'm gonna drug test you. If you are negative, put the lid on it, pour it out, throw it in the sink, walk out, and I enter it in the computer. If you're positive but will not emit, I fill out a lab form, we send it to the lab, then when it comes back from the lab, we do it. With this being in court, he was not on my caseload. I tested it and I threw it away and I never thought a thing about it. I had to go back and listen to the court record to see what it was positive for because I don't take notes on it. If judge asks me to do it, I do it and I walk in and say, Judge, this is what it is, and I forget about it because it don't have nothing, I don't have any follow-up to do with it.
So I can assume that's a no, you didn't do any paperwork
I've
associated.
none.
So as you sit here today, can you tell me, I guess, can I look at the paper on that? Where I reference it correct, the plastic cover of the, drug test. Everything, the other cover,
When I peeled off,
yes. My approach with the Sean, no, the plastic one and stuff.
The bag.
And all that, yeah, yeah. Before you administer this test, I guess, did you, confirm the catalog number or the line number or the expiration date of the test?
I
you
did
do
not.
that?
However, when I left my office that morning, I put a new test in my bag and we rotate them in our office to make sure we use the oldest first. And I don't look at that because we get drug tests in, we get 1,000 per box and we go through 500 a month plus at our office. So they stay in date. That's not something we have to worry about because this one right here is not out of date until 2025 and we're in 2024. This one's got over a year from today. So these tests will be gone by then.
So, I guess a yes or no to clarify. Yes or no, you did or you did not check the expiration date of that test?
I did not physically check it before I tested it.
So as you sit here today, you can't positively say that it was in date. You're just making an assumption.
Yes, however, the other test that's in this bag was in here that day and they're in date. So I assume it was, but I cannot positively say it was.
And I think you said the specimen was not lab?
It was not lab.
Okay.
We cannot lab test. The only tests that the state will allow us to lab are ones that are from our office because probation and parole has to pay for them tests. And where the judge was asked me to do it. Now, if the judge looked at me and said, I want that lab, I could have done it and probably got away with it. Probably got my hand smacked, but Judge Williams asked, I'm going to do it. But if he does not ask, I'll say, okay. And I walk back there and I dumped it in the toilet and threw the cup away.
But usually, I guess it's on your caseload or I think that's what you said, or.
If they're on my caseload, the only way I lab it is if they don't admit or I have a reason to lab it. We only lab probably 1/10 of the tests we do because most people, once you test them, they will admit to use or they're negative. So,
And in this case, Mr. Smith denied having anything in his system. He said, I guess, said he'd be clean or good. I'm not sure
Yeah.
what your word was.
he denied it, but the judge didn't ask me. I told the judge what it was and he took him into custody, so I threw it away.
Were you ever asked by Mr. Smith's attorney about the test results or anything?
I don't recall him asking. All I recall is walking out here, and I think I even walked up to the bench to show the judge the cup, and I said it, and I turned around and walked back. I don't recall him asking me any questions.
Did Mr. Smith's attorney confirm the results of the test? Do you recall if you showed it to him or not?
I don't recall that.
Did Mr. Smith's attorney ask for the specimen to be labbed or anything?
He did not.
Do you have a specific amount of time, I guess, when do you just swish the contents? What do you do when
Your
you?
Honor, I don't guess it's like getting territorial when I'm asking that.
No, that's not, Your Honor. How long did you wait before you tested that or read the results?
When you pull this back, the urine will go up the thing, and once it goes up, you'll get lines. And once it is lit up, you can tell, and it was ready to read because the top line, all of them have a top line. If it's negative, they only have one line. If it's positive, they have two lines. If it's negative, I'm getting that backwards. If it's negative, they have two lines. If it's positive, they have one line. And all the substances except these had two lines. So it was ready to read.
So in your training, you're not told to wait a certain amount of minutes or anything, just when the lines are filled up or is
No.
that what it's done?
And if it's slow coming in, sometimes you can start to see a line and it'll take just a second, but his that day did not have any lines. And I'm also thinking I waited, I think the judge was dealing with the case when I come out of the bathroom, so I waited a couple minutes before I showed it to him, so.
Thank you, Carson.
You're
I have no other further questions.
Excellent. Have you got anybody else you'd like to call?
No, Your Honor.
Okay,
I would make the argument.
go ahead, Dr. Arden.
Your Honor, as we stand here today, Mr. Smith came, to court, and I guess the court observes what they deem to be him being under the influence. Mr. Smith was appointed an attorney that, and through no fault of his own, I don't know, didn't inquire about the drug test that was taken. He didn't inquire about whether the date was expired. He didn't check, normal things that should be checked by a competent attorney to make sure that a drug test is valid. The testimony revealed that he doesn't know exactly what the date is. He's assuming that it was a test that was in date. He doesn't say that Mr. Smith or his attorney asked for the specimen to be labbed. Our argument would be, Your Honor, that this is an unreliable test. Mr. Smith didn't have adequate assistance of counsel. In fact, I'd call it ineffective that he was here, and we request that he do another test today, and that way he's got his attorney here today where I can check the expiration date, the lot number, and I can see that everything's done correctly, because I just don't think it was done that way the first time. And if it's all correct, then there'll be no objections from me from it. But I object to this test because it's not been verified that it was a test that was valid.
There's several things wrong with this case. Number one, I don't think Mr. Wittenberg should ever have told him not to appear in court, because in the interim, while Mr. Wittenberg had a conflict of being here, Mr. Smith had already been charged with a felony, which is the basis of my bond revocation. He came in here, he was late, and it was apparent, I think I was the one that asked the court to test him because he was in such bad shape, he barely could function. He was tested and he was taken into custody. None of his rights were violated. There was a proper test. The only thing Mr. Smith had done, he committed the felony. He didn't appear in court on time, and he's high when he got here. Other than that, he was probably doing okay.
Your Honor, a very short rebuttal, just so I can clarify, because I don't want to be in conflict with the court and not doing what the court's ordered and stuff. But if I can't be here and I tell my client that I'm not going to be able to be here, that he has a right to counsel as we go forth in the future, should I tell him to come to court without counsel?
Well, you're the only person I have this problem with. So I really haven't thought about that. Everybody else appears with their client, and if they can't be here, they have someone else to be here in their presence. So I don't really know the action, but I will tell you this, you do not have the authority to tell your client not to be here. And if your client had come here, walked in the door, had not been stumbling around and not been under the influence, he probably would have been able to go out here. Was there a warrant out for him?
No.
He was under a bond
He was
condition.
under a bond condition, and I filed a motion to revoke his bond, but I wasn't going to have a hearing because Mr. Wittenberg couldn't be here.
And why were you going to revoke it for?
Well, I've got my witness at it. He's charged with assault, domestic violence, wanton endangerment in the underlying case.
Yeah.
There's a new felony one out of him for assault, domestic violence with another lady. So that's the reason I filed the motion to revoke the bond.
So he's going to be arraigned on that or what?
No, I had to
The
get
bond revocation.
special prosecutor to do this.
Okay.
Your Honor, unfortunately, I'm a sole practitioner and I try to accommodate the court. I've even at one time went to Cumberland County for a negotiation conference on Mr. Smith's case and appeared at 1 o'clock I was supposed to, and the Commonwealth wasn't there. I've never gotten any official explanation. I never got a call to the office or anything like that. But I appeared like I was supposed to. I've always tried to accommodate the court and do it, but unfortunately I am a solo practitioner and I can't always be here if I've got trials set from other courts, and they're usually trials that are set well in advance. But
We're losing focus here. This case is not about Mr. Whittenburg. It's about Mr. Smith's conduct. Mr. Smith's the one that showed up high here. He's the one that's indicted for assault. He's the one that committed another assault while he's on bond. It's not about Mr. Whittenburg.
Well, Your Honor, we're here on a drug test. I've made my concerns known to the court, but I think it's valid.
Here's the thing about it. There are two or three things that make this happen. Number one, the Commonwealth observed his actions. I had already observed it. When he calls attention to this gentleman, I look at him. The Commonwealth, it's not enough that they come up here and want somebody drug. I have to observe myself. And I did observe. The guy was not functioning. Okay. So I asked probation and parole to do a test. And you might want to challenge that test, but there are thousands of these tests relied upon all the time, not as for the quantity, but just the presence of these things. Okay. And all the time, there are decisions made on the presence of these multiple drugs that he had presence here. So you can take it up if you want to. That's your prerogative. But I was a sole practitioner. If you cannot be here, when you do your schedules, if you're going to practice in Clinton Circuit Court, you should not schedule things on the one day a month that we're here. If somebody tries to schedule something that you got here, you're going to say, I can't be there that day. That's Clinton Circuit Court Day. Or you get somebody else to be here. There are a lot of lawyers that for $100 or come here and make sure you're protected and whatever. So, but as Mr. Stockton said, that's not the issue. The issue is he had a bond revocation here, which we're going to have now. Okay.
I'm ready.
Okay, you ready?
I call Haley Harbor as a witness.
Okay.
Since this is domestic violence case, I'd ask them to say that I won't have this.
Yeah, y'all clear, y'all clear. Okay, have her sit right again. Okay, Mr. Stockton, will you state your case for bond revocation?
Yes, Mr. Smith is under bond.
Get behind the podium, get behind the podium.
On 23 CR 67. While out on bond during this time, he was cohabitating with Miss Harbor and committed the acts probably of unlawful imprisonment and assault. And that's what she's here to testify about.
You raise your right hand, please. Swear the testimony about gives the truth, whole truth, and nothing but the truth. Okay, proceed.
Miss Harbor, at one point in time, did you and Mr. Smith live together? You'll have to speak up.
Yes.
Then where did you live?
You're gonna have to speak up, lean toward the microphone.
Okay, and how long did you live there with him?
Probably from
And
December.
you gotta speak up, like you're yelling for somebody outside, yell, okay?
Maybe like December to last month, so like,
Okay, after he allegedly hit you and kept you at the residence, did you leave? Have you been back?
yes.
You have, okay. You remember taking out a warrant on Mr. Smith?
Well, I ran to the neighbor's house. and they
Okay,
called-
just tell us what happened that day. Have you been threatened or bribed and don't want to tell your story today?
No,
Okay. Well, you went to the county attorney's office, didn't you?
I just,
You told your story down there, didn't you? I can read it to you if you want me to.
Read your statement.
Says the fine Haley Harbor states that during April the 3rd, 2024 through April the 4th, 2024, the above named defendant unlawfully committed the offense of assault in the second degree, a class C felony when the defendant intentionally caused physical injury to another person by means of a deadly weapon or dangerous instrument. The fine.
Your Honor,
Yes.
that's her statement, or she said assault, third degrees, that's her statement, or is that,
Well, that's the warrant.
that doesn't seem
Read
like
your
that's her
statement, you got a
statement?
copy of her statement.
I thought that was it. I'll just ask if you can, bring me the district court file, please. I thought I had all this,
Okay,
just the
young
complaint.
lady, here's the deal. I know this is uncomfortable. You've signed a statement. You need to tell the Commonwealth what happened there that day. And you need to do it in an audible voice, okay? Ask her again.
Okay. Evidently, this happened on April the 3rd, 2024 to April the 4th. Is that correct?
Yes.
Now tell us what happened.
He just flipped out.
He flipped out. Okay, when he flipped out, did he strike you or hit you? He did?
Yes.
In what way?
Your Honor, he's leaving. I would ask.
That's all right. Overrule your objection and let this young lady testify as to what happened. It's difficult on her, which you ought to recognize. Thank you.
I do, Your Honor.
Proceed, Mr. Stock.
In what way did he strike or hit you, Miss Harper?
Just kept hitting me.
He hit you with his fist?
Yes.
Okay, you also said in your complaint he kicked you, is that right?
Yes.
And he hit you with a belt and belt buckle? Is that a yes?
Yes.
Okay.
Again, Your Honor, I would just want to preserve for the record that I'm objecting to the
Overruled.
Okay. Now, you also allege that he wouldn't let you leave the residence, is that correct?
Yes.
Okay. In fact, when you left the residence, you had to go to a neighbor's house, didn't you?
Yes.
And you saw Connor Duval, who's works for the Tennessee Highway Patrol. He's the one you first saw, is that not correct?
Yeah, the door was just open, so
Okay. And you told Mr. Duval what happened, didn't you?
yes.
Okay, and after you saw them, ultimately you went up at Michael Rames's office and signed a complaint as to what Mr. Smith did to you. Is that correct?
Yes.
I have no further questions.
You may inquire.
Prior to the April 3rd and 4th incident, how long did you all live together or, known each, I guess lived together? How long did y'all live together? Did y'all live together?
Since this December of 2023.
Since December 2023? Prior to this incident on the 3rd and 4th, had he ever done anything like that to you prior to that?
No.
I guess April 2nd, 3rd, 4th, had you consumed any drugs, narcotics, or anything like that?
No.
If you know, is there a reason why he, I think you said flipped out?
You just, I think we both had a lot going on.
I'm sorry, I can't hear you.
We both had just a lot going on as far as, problem, just in court with over our kids and stuff. And he was under distress.
Okay, did you hit him first or, what exactly happened then? I mean, was there an exchange? Was it a fight or was it just him or what?
I'm not sure what made him do that. He's never done that. I don't know.
No further questions, Sean.
No regret.
Okay. Will this witness be excused?
Yes, sir.
May be excused. You have any other witnesses?
Have no other witness.
Okay, you have anybody you'd like to talk?
No, you're okay.
You'd like to make your case?
I would, Your Honor. I would like for the court to take note of the fact that Mr. Smith is charged in the original case with assault, wanton endangerment, and intimidating the witness in the legal process. And I'm pretty confident to say, I don't know if anything's like that's happened in this case, but I've got him on.
Just for the record, let's recite what the underlying facts in the case. Please.
In the underlying case, he allegedly attempted to run over his current wife, which was witnessed by a neighbor who threatened her. And I've got him on audio tape where he's screaming at the top of his lungs, telling him he's going to murder her. And that's on audio tape. So I feel very comfortable saying that in front of the court. In this case, you heard what Ms. Harbor said. He struck her with a belt, he hit her with a fist, kicked her, and he kept her there 2 days. So he's dangerous to himself and to others. And I'm asking to be held out without bond, and we'll set this case for trial.
You can come up and make your argument.
Your Honor, you heard the testimony that she said he had never done this before. I think that they'd lived together since December of 2023. She wasn't able to testify where it was a mutual altercation as far as who struck who first. I don't think, other than this allegation, that there's been any other allegations against him as far as doing anything improper after he was put on bond in the first case. I would agree this is not good if this has happened. I'm not saying it is. But I don't think he's a danger to anybody. He has very little criminal record that I'm aware of. I think he's got a few things, some traffic stuff, and I think maybe a possession charge, but nothing major, nothing violent that I saw in my records. I don't think he's a danger. I don't think he should be revoked. I mean, if the court wants to do some type of restrictions, such as a house arrest or something, I feel like that'd be more appropriate. And just as Mr. Stockton said, I do think we need to set the original first case on for a trial date and get it tried as quickly as possible.
Mr. Stockton, there was that from the district court file, if you'd like to attach that to her testimony.
That's what I was reading from and the complaint with her signature on it.
That's what she, I'll admit that to the record, just exhibit. You want to bring it back up?
Yes.
Put it, let's leave it. Okay, well, you know, the fact that someone that this, I'm kind of incredulous at the argument that this frail little girl here would be that testified, this young lady would be a threat to your client in a fair fight. I don't know whether he should be afraid of her, or have to kick her or beat her or hit her with a belt or that sort of thing if they got in some kind of altercation. I will just tell you, obviously she was intimidated here, and the president looked like to me. And when she did her statement, she says that he denied her leaving the residence for the 2 days. That during the past 2 days, he has beaten her with a belt buckle, stomped on her with boots. She went to the home of a neighbor, tried to escape, and it goes on down through there about all the things he did. Now, I know it's an allegation. It's a sworn statement. But then you have the situation on top of that, that he's already out on a violent charge where he did this to another woman. And he's been indicted by a grand jury on that. We let him out on bond. He comes up here under the influence with drugs in his system. The drugs in his system in of itself would be a violation of his bond, whether he was acting out of sorts or not. So I'm going to revoke his bond, hold him without bond. And then you have a problem, ma'am? Would you like to go somewhere? There's room for you too. Okay, we leave the courtroom.
I'm not asking for the money to be forfeited. I'm just asking to be held.
They're not gonna forfeit anybody's money. Nobody's money's gonna be forfeited. Anybody that signed his bond to get him out, did so to get him out, and he hasn't done, it's not like anything else, okay? So let's get your calendars and let's set this case for trial. He's gonna be held without bond. And you have your calendar with you?
I do.
Let's look, what are the first dates that you have available? We'll check the defense counsel.
I would have the first week of June available, the third, fourth, fifth, sixth, and seventh.
What about, the 29th, May?
Yeah, I have that available.
Now, let's go the week before that, 21st and 22nd. Do you think that trial, that's a Monroe County trial, McClendon? And so you think that's going?
Miss Gordon Anderson doesn't think so.
We don't know for sure yet.
We don't know for sure.
Yeah.
Well, let's schedule it for the 22nd, right? Okay?
Okay.
And can you make it on the 22nd,
I
Council?
can, Your Honor. I have nothing on my calendar.
Okay, good.
Is that all, Your Honor?
That's it. Thank you.
So that's further in front of court. May I be excused?
Absolutely.
Thank you.
Ray versus Ray, a Cumberland County case. This is 23 CI 00060. Kristen Ray versus Christopher Ray, a motion to compel.
Yes, Your Honor. On behalf of the petitioner, I had served the defense, responded with some discovery requests back in December. I didn't receive any response. In March, I filed a motion to compel. That motion was supposed to be heard last week in Cumberland County. I allowed them an extension to move it to this week to get the responses, and I still don't have everything I need.
Tell us what you,
I'm still waiting on bank statements, and
well, let's be more particular than that, so
from
you
January.
can make a list
Yes.
this way, okay?
Yeah, January of 2022 until present, just bank
January
statements.
of 2022 to present, okay?
For bank statements, and
And
then
whose accounts would they be?
it would be the respondent, just any bank account that he has.
Christopher Ray?
Correct.
Okay.
And I'm also needing his retirement statements from January 2022 until present.
What's the significance of January 2022 as far as the retirement statements?
Just from that time period, I know that's when he had, in 2022 is when he started a job where he was getting retirement. We're just mainly,
Okay, what company is that with?
it's an electric company in Bowling Green.
Works for Warren RECC, Your Honor.
Okay, I just want to be specific so you know what to reply to. Is there anything else you need?
That's it. That's all I'm waiting on.
Okay, do you have any response to that?
Your Honor, my only response would be, I understand the retirement statements. We've got no issue with that. We just haven't been able to procure those yet. I don't understand the need for the bank statements. I'm not sure where it's relevant, what my client is spending his money on,
Was they
especially.
married during the time period?
Yes, Your Honor. They were married during that time. I mean, I think it's relevant to see if he's having any other income, if he's liquidated any assets, if there are more assets being purchased, during that time. I mean, I think they're very relevant.
Well, I would put an order on it that you and your client can see that no copies of it can be made and nothing can be disclosed by you of
That's fine.
any nature on there. I don't see how you can look at these sort of things without having some access to bank records. Okay.
If that's the court's rule, and we can get that.
And Your Honor, just and I know because of the motion to compel, my client is going to be out some attorney fee, and, we've been waiting on these since December. I'd love to already settle this divorce, and they've been the holdup. If the court would consider a reasonable attorney fee for my client. Just to consider it.
Yeah, well, I'm gonna award $350 attorney's fees, but I will suspend that if you comply with the order within, let's say, 10 days, okay? Can you do that in 10 days? I think that'd be fair.
Thank you.
That
Yeah,
gives you plenty.
that's fine.
I
Yes.
think we can get that in
She
10
doesn't
days.
do it within 10 days, she'll order $350.
I appreciate that.
Attorneys,
We
okay?
can do that. That's fine, Judge. Thank you.
Thank you.
Thank you, Your
very
Honor.
much,
Thank you.
yeah.